Welcome to week 6 of business law. This week we're going to look at chapter 5, which covers crimes. You might ask yourself, what are we doing covering crimes? This is business law. Not an unfair question to ask. Hopefully you won't need much information about criminal law during your business career. I certainly hope that you're embarking upon a career that'll avoid criminal proceedings by and large. But certainly there is some overlap with business law and criminal law. We'll cover the issues you would most likely encounter when you're dealing with a career in business. We're not going to cover every possible crime. I hope that you won't ever have to deal with needing to know the elements of murder or rape or something like that in a regular business career. We're not going to spend much time on that stuff. Really, what I'm going to try to do is give you an overview of how our criminal law system works, because you might interact with that in some way, form, or fashion. You never know. You might have employees that commit crimes. Certainly, we have instances of embezzlement and things like that that happen and make our local news from time to time. Sometimes you may need to steer your business clear of criminal liability, and so it's helpful if you understand kind of the elements of what criminal law really covers, what defines a crime, and those sorts of things. I think it'll help you be a more well-rounded individual if you know something about this. So we're going to take some time and look at criminal law just a little bit. Let's start out by defining what a crime actually is. Crimes are a lot like torts in many ways, and we certainly spent some time looking at torts. However, you may remember a tort is a wrong against an individual. A crime is a wrong against society as a whole. The fundamental purpose of a government is to protect its citizens, to provide order and stability in that kind of environment to where people aren't running around bashing each other's skulls in and stuff like that. We need a civilized society. And so the government steps in, creates criminal law to prevent wrongs against that order that we want in society. So the whole purpose of criminal law is to enable government to carry out that most basic purpose, just creating that order and predictability, that stability that we need for society to function. The criminal code defines the various disruptions to society as crimes. It allows for the punishment of individuals who interfere with that peace and order that the government is trying to provide. So again, a tort is a private dispute. That's the main difference. A crime is against society, that law and order that government is concerned about. So that's really the main difference. And you'll see that there's a lot of overlap between crimes and torts and the different kinds of conduct that we're concerned about. But this isn't just about money changing hands, what we'd see in a tort case. This is about some wrong against society, and certainly more is at stake than just we'd see in a normal tort case. Speaking of punishment, punishment for crimes can take several different forms. With a tort, again, we're talking about money changing hands typically, but this is more serious than that. We're talking about someone losing their freedom, being sent to prison. We can also be talking about payment of a fine. Some states and the federal government impose the death penalty for especially heinous acts of murder, and that is limited to murder these days. There are no other crimes for which the death penalty is imposed in the modern world, in the United States at least. So we're talking about really serious stuff here. There's a lot at stake. There are also lesser forms of punishment, such as probation or community service. And the Constitution tells us, basically through the Eighth Amendment and a lot of Supreme Court cases, the punishment is supposed to fit the crime. So the more serious punishments are reserved for the most serious crimes. So there's supposed to be some kind of proportionality there. Let's talk about why we punish people for crime. What are we trying to accomplish? And that kind of helps us understand kind of the philosophy and thought process behind our criminal law. The first goal of punishment is incapacitation. Basically, if we throw someone in jail, or we execute them for that matter, they cannot go and commit another crime. We're taking them out of action. So, if somebody has knocked off 7 different gas stations, we lock them up in jail, there's not going to be an 8th one that's going to be robbed by this person as long as they're locked away. So that's one goal of punishment, is to keep that person from committing another crime. Also, we have the goal of deterrence. And if someone knows that they're going to go to jail if they commit a crime, maybe they won't commit that offense in the first place. That's the idea of deterrence, having that punishment available is supposed to have a chilling effect on people who are thinking about committing crime. And not only the person who gets punished, they may be deterred from committing another crime, but we're hoping that, if us, citizens see, some of our neighbors in the community going to jail for certain activities, we're not going to go commit that crime ourselves. And so we are deterred when other people are punished. And so not only are you deterring the person who you punish in the first place, you're deterring others by punishing that person. So that's the idea anyway. And certainly this doesn't work as well as we would hope, because it seems like a lot of criminals don't think about the consequences of their acts before they act. So this doesn't always work real well, but this is one of the theories of punishment. We also have as a goal of punishment rehabilitation. In other words, we're hoping that by punishing someone, they're going to see the light and they'll become law-abiding citizens. We will turn them into a better person by sending them to jail. That doesn't, in my humble opinion, doesn't seem to be usually what happens when somebody goes to jail, but certainly that is a goal. We're trying to, take them off the street and help them turn their life around, and that is one of our goals when we punish someone for a crime. The fourth theory of punishment is the most controversial, and that is retribution. Basically, a bad person gets their just desserts. They get what's coming to them. This is, as I said, a controversial stance because, it's kind of an eye for an eye sort of mentality. And, we like to think that as society, we've evolved past something like that. We're trying to, help this person. We're trying to get them off the street, certainly. We want to rehabilitate them. But if you're just, focused on retribution, just giving them what's coming to them, that seems kind of brutal, a little primitive to our modern sensibilities. So that is the most controversial one that comes up a lot of times when people are talking about the death penalty. We're supposed to be above that as a society. If somebody kills somebody, we kill them, that we're supposed to be above that. And so there's a lot of give and take on that one. But that certainly is, purging evil from our society is a goal of punishment, and giving people what they deserve is one of the recognized theories of punishment. So those are the theories that are kind of behind what we impose upon people because they violate the criminal law. When we look at different crimes, we are looking at something that's defined by a statute. The Constitution demands that before something is a crime, it has to be spelled out word for word, black and white, by a legislature somewhere, either the state legislature or Congress at the federal level, something like that. And when we look at torts, we didn't really talk about this a whole lot, I don't guess, but a lot of torts are just defined by case law, by that old common law that goes clear back to jolly old England and stuff. We know what assault and battery is because courts defined it as such in the 1500s or whatever, and it's just come down to us over time. Well, there were common law crimes once upon a time that were defined by case law, and the Supreme Court has said that's unfair, and because you're taking someone's freedom away, due process, fairness demands that before we do that, we have to give them a chance to know what they're doing is wrong, and we don't expect people to sit around reading case books looking for crimes that they don't want to commit, or trying to figure out what the definition of a crime is being defined by case law. That's just, we can catch somebody unfairly if we do that. And so crimes have to be spelled out in a statute in order for them to be valid. A state prosecutor exists in every county in the state. And the purpose of the prosecutor is to prosecute state crimes. At the federal level, we have federal crimes, and we have a U.S. attorney in districts that look a lot like, the federal district court districts, probably the same kind of territories. And so each one of those districts has a U.S. attorney and a number of assistant U.S. attorneys whose job it is to prosecute people who violate federal criminal law. Not always, but generally, if you see a case that's styled something like State of Missouri versus Smith, or just State versus Smith, it's probably a criminal case. It doesn't have to be. The state of Missouri can actually sue someone in a civil case. That happens once in a while. Like if you agreed to sell something to the state highway department, asphalt at a certain price, and you renege on that, they can sue you in a civil case, and so it would look like this. But typically, 90% of the time, if you see a case, where the state is a party, it's probably going to be a criminal case. One important difference between criminal and civil cases, which we already touched on a while back, is the burden of proof. And you remember that with a tort case or any civil case, our burden of proof is more probable than not, the preponderance of the evidence. We're talking about 50% and a little more. We just more sure than not. That's all we care about in a civil case. Well, with the criminal case, we're going to that beyond a reasonable doubt standard that we're familiar with if we watch a lot of crime shows and stuff on TV. And that is not 100% sure, but pretty darn sure that, probably 95 or 98% sure. We don't have to rule out that maybe the aliens did it, or, the defendant had an evil twin. We don't have to rule out all those crazy theories, but we have to be pretty sure that somebody is guilty before we are willing to convict them of a crime, beyond a reasonable doubt. Also, we have the presumption of innocence. Innocent until proven guilty, a familiar phrase to us probably. So when somebody is accused of a crime, the presumption always is that they are innocent, and we're going to treat them that way until it's proven otherwise. And so not every country in the world acts that way, so that's certainly an important right that we have as American citizens. Also, in a criminal case, in order to have a conviction, juries must be unanimous. States vary on this in civil cases. A lot of times you don't have to have all 12 jurors. Maybe 9 of the 12 would be enough to render a verdict in a civil case. Just depends on the state rules. But in a criminal case, a jury must be unanimous. And so not only are we going beyond a reasonable doubt, but you have to convince all 12 jurors that this crime actually occurred. And that's a pretty heavy burden if you're a prosecutor trying to convince 12 people beyond a reasonable doubt that somebody is guilty of a crime. So not an easy row to hoe if you're a prosecutor, but we would rather turn a few guilty people loose than convict innocent people, is the way the system is set up. And so that's the way that criminal procedures work. Crimes can be classified in a few different ways. The most serious type of crime is a felony. If you have a felony on your record, you may have trouble getting certain jobs or, that sort of thing. A felony is serious. It's defined as a crime in which the possible punishment is 1 year or more. That does not mean you were actually sentenced to spend more than a year in jail. It just means that you could have been sentenced to that much for committing that crime, because the seriousness of the offense is determined really by the seriousness of the punishment. And so if we could send you to jail for 5 years for an offense that you committed, but we only put you on 3 months of probation, you're still a felon because that crime was so serious that up to 5 years of jail time was allowed as punishment for that. So that tells us that was a serious crime. And so that's how we define that. It doesn't mean you were actually sentenced to more than a year in jail. It means you could have theoretically been for that offense. And so if that offense carries that kind of punishment with it, it's very serious, and we call that a felony. A misdemeanor is below a felony. The greatest possible punishment for a misdemeanor is less than a year in jail. And so if the greatest possible punishment for a particular offense is 6 months in jail, and then it's a misdemeanor. Doesn't mean that you spend any time in jail again, but if you could have, then it's a misdemeanor. But if there's any possibility you could spend more than a year in jail for it, it's a felony. So that's the main distinction between those two. We also have what are called infractions or violations, depending on the state. Those are usually pretty minor offenses. Usually we're just talking about a fine. It could be something silly, like a fish and game violation, you shot too many raccoons or something like that, or some sorts of parking violations and things like that aren't even considered serious enough to be a misdemeanor. They're just considered an infraction. So again, we're normally just talking about a fine. Also, each state has its own regime for classifying crimes. And so you might have a situation like where a state has taken all its felonies and broken them down into Class A felonies, Class B, Class C, and so on. And most states do some variation on this, and they'll have sentencing guidelines that for a Class A felony, you can be sent to life in prison, but for a Class B, up to 25 years, or a Class C is only up to 10 years, or so on and so forth. So And again, this is a point that I probably should have emphasized earlier, but each state has very different criminal statutes. And most of the time, the same types of things are crimes, but there is no standard criminal code that's been adopted throughout the United States. And so each state has its own little system for this kind of thing. So they may vary from state to state, but each state will have some kind of way of classifying its crimes this way. Let's talk now about the elements of a crime. Similar to a tort, you have to have satisfied all elements of a crime in order to have committed it. Remember, with torts like negligence, we have 5 elements. You have to have all of them. If one is missing, you're not guilty of negligence. Well, similarly, each crime has elements required of it as well, and we can break those into 2 major types. First of all, we have to have a wrongful act. Actus reus is the term in Latin. Basically, we don't punish people for thought crimes. If you just sit around thinking bad thoughts, naughty thoughts about something, we're not going to throw you in jail for that. You have to have committed some kind of action that is punishable. And so each crime defines this differently, but there must be some kind of action on your part before you're guilty of a crime, some kind of wrongful act. But we also require a culpable mental state, or mens rea. And that means that just doing something won't mean that you're guilty of a crime. You also have to have some kind of evil in your heart when you do it, some kind of evil intention. And each crime, again, defines this a little bit differently, perhaps, but each crime must have both the wrongful act and the culpable mental state. And each, the statute that defines a crime will give us some kind of clue about this, but each crime requires both an act and a mental state. If one of the 2 is missing, you did not commit a crime. You may have done something else, but you didn't commit a crime. And so each crime will define this a little bit differently. Well, let's take a look and kind of see how this works by looking at a situation that might be a crime, but for the fact that we don't have the culpable mental state, or the mens rea. Example 1. Johnny is cleaning his gun. Without warning, the gun discharges and hits Johnny's friend Brad, killing him. Well, let's stop there for a second. First of all, is killing people a bad thing? Yeah, that could be murder, couldn't it? That's a crime we're all familiar with. Taking someone else's life can be murder, okay? Well, is it murder here? Certainly we have the activity associated with murder. We killed somebody. But was there any intention to harm? The answer is no. This was an accident. Johnny did, in fact, discharge his gun and kill his friend Brad. But was there any intention there? Was there any evil in his heart? Was he trying to commit some kind of horrible act? No. This was a total accident. And so we cannot convict Johnny of murder in this situation. Maybe negligence or something else, but not murder, which requires an intention to kill somebody. With murder, we have to both kill someone, that's a wrongful act, but we also have to have some kind of intent to cause them harm. And here we don't have that intention. And so we don't have mens rea, therefore we don't have the crime of murder, because one of those 2 elements is missing. Well, let's turn it around. And what if we have no act? What if there is no wrongful act? Example 2. Shirley hates Linda with a passion. Shirley gets a deer rifle and intends to kill Linda. Shirley shoots at Linda, but she is a bad shot and misses. Linda is completely unharmed. Linda may not have even known this happened. She just heard a gunshot, didn't know it was aimed at her at all, okay? Well, first of all, maybe some other crime has occurred. We'll look at attempt later on. She was trying to kill somebody here, but was there a crime of murder? The answer is no. Did she want to commit murder? Yes. Was there evil in her heart? Absolutely there was. She really wanted to do some harm here. And so we have that evil intent. There is mens rea, but she didn't actually get the job done. There's no act. She didn't kill anybody. And so, she may be guilty of something else, but it's not going to be murder, and because she didn't commit the wrongful act that is required for murder. So, again, we have to have both. Just having the evil intent is not enough. There is no act here, so we don't have murder. Well, what if we do have both? If we have a wrongful act and a mental state? Example 3, George hates Bryce with a passion. George gets a deer rifle and shoots and kills Bryce. All right, well, we have an act. Somebody dies. George killed somebody. We have a mental state, there's an evil intent, thus we have the crime of murder. Somebody committed the crime because there was both a wrongful act and a wrongful mental state at the same time. So just about every crime is going to require both a wrongful act and an evil mental state of some sort. Well, having established that, let me give you the exception. There are very few crimes that are considered strict liability and require no mental state. This is kind of weird because most of them, almost all of them do, but there are a few where you can be punished for doing the act no matter what you were thinking when you committed the offense. Why would we do that? Well, typically these offenses, first of all, have relatively low criminal penalties. We're not going to send you to life in prison for a crime that required no mental state. Normally, that's not going to happen. So typically, not always, typically these offenses have relatively low criminal penalties. And they are normally used in situations where we want to encourage people to be extremely careful. Doesn't matter what you were thinking at the time, we just want to do everything we can to avoid the harm. In some states, depending on how they define it, statutory rape can be in this situation too, which that is having sexual relations of some kind with a minor, someone who is below the age of consent. And a lot of times those minors may be willing participants. They want to have the sexual relations, but they don't legally have the ability to consent. Well, we really want people to be extremely careful in this situation. And so, depending again on the jurisdiction and all of that, statutory rape can be this way because even if the overage person who's participating in this activity genuinely thought, had every reason to believe that the person they're having sex with was above the age of consent, if they really weren't, they can still be convicted of this crime. So we just really want people to be extremely careful because we don't want kids to be having sex with people who are overage, basically. We want them to be extremely careful. So again, this is the exception, not the rule. Almost every single crime is going to have some kind of mental state requirement as well as an act requirement. But there are exceptions, and I felt the need to point that out. Let's talk now about kind of what happens in a criminal case, how it kind of goes down. Typically, there is a situation where the police believe that there is probable cause that a crime has been committed. And we'll talk more about probable cause here in a second. But the police, for whatever reason, believe that a crime is being committed, and they amass some sort of evidence to that effect. So someone's arrested for a crime, then the prosecutor gets involved and files a document called an information with the court. It basically is just a formal accusation that the defendant committed some kind of crime. Sometimes we'll have a grand jury indictment rather than an information. A grand jury is a collection of citizens who serve on a jury. It's like jury duty, except they're not hearing a particular case the entire time. Instead, the prosecutor can bring them evidence about a crime that may have been committed, and the grand jury will get to decide who deserves to go to trial. Is there enough evidence in this case to actually bring charges against someone? And the grand jury will make that decision. Grand, of course, just means big, like grande. But the opposite of a grand jury is what we call a petite jury or a little jury, which comes from the French. And that's the jury we're used to seeing on television, the 12 people, hearing a murder case or something. But a grand jury performs an important function because, the prosecutor will just say, hey, grand jury, here's the evidence we have. Should we charge anyone for this? And the grand jury will decide yes or no. And if they decide yes, they will issue an indictment formally accusing someone of a crime. So some crimes, this is how that happens. But in any case, there are formal charges filed. Then the defendant will be brought before the court and arraigned. When they are arraigned, they have the ability to enter a plea to the charges, normally going to be guilty or not guilty, typically. And if they, won't say anything or whatever, the court will normally enter not guilty on their behalf. There are some situations where a defendant is allowed to plead no contest, or the Latin is nolo contendere. That situation, basically the defendant is saying, I'm not saying I'm guilty, but you have an overwhelming amount of evidence, so I would never win that case. And so they just kind of give up. So that happens from time to time, that they don't actually plead guilty, but it's kind of like pleading guilty. So they're still punished for that. Anyway, so that's how a case gets underway. And a lot of criminal cases, maybe most, never get to the trial stage. A lot of them are plea bargained. And we're probably, if we watch court shows or whatever, we know what that situation is like, that the defendant may plead guilty to a lesser offense and end up being punished for that. And that provides a benefit to the prosecution because they don't have to waste the time and effort to go through an entire trial, which trials take a huge amount of time, a huge amount of effort, are very expensive. And so justice may get served in some form or fashion without having to go through all of that. And that way, the defendant doesn't have to get there and be embarrassed, hearing all these people testify against him or whatever. And this way they can have a lesser sentence than they might have if they'd been convicted of the crime they were originally charged with. So plea bargains happen a whole lot for various reasons. If the case does go to trial, the procedures are very similar to what we talked about with a civil trial back in week 2. So, both sides put on their evidence, they have their arguments and all that sort of thing. Opening statements, closing statements, and all of that stuff. But remember, all the jurors have to agree. If they don't, then we have a hung jury. And so if the judge decides that the jury will never be able to render a unanimous verdict, he'll call a mistrial. Then the prosecution will have to decide, do we want to try this over again, or are we just going to let it go? And depending on the case, they all decide that one way or the other. But if the jury does all unanimously decide that beyond a reasonable doubt they're certain the defendant is guilty, he will be locked up for a while, normally until he's formally sentenced and sent off to the pokey. So that's kind of how a criminal case unfolds. Let's start looking now at individual crimes and kind of see what their elements look like. Again, each crime is defined by statute and each state is different. What we typically look at when we're talking about crimes is we kind of look at the old common law definition that was developed over hundreds of years. But when each state passes their criminal code, they'll define things a little bit differently. And again, we'll get into, as we see further in business law, there are things like the Uniform Commercial Code, the UCC, which has been adopted almost without any changes by almost all 50 states, so that every state's the same. Well, there's nothing like that in the criminal law. Each state is a little bit different, and they're kind of particular about that, and so for whatever reason. So crime in each state is a little bit different, but it's defined by statute. But every state also has a lot of things in common. But and almost everywhere, robbery is going to be illegal. Well, what is robbery? Well, looking at the common law definition, robbery was, first of all, element 1, the taking of personal property from another person. 2, by using force or the threat of force. And so this isn't just some kind of pickpocketing situation. This is where you're overpowering someone or you're threatening their life in order to deprive them of some piece of personal property. So that's the definition of a robbery. Worth pointing out that you don't actually have to use force. Threat of force is enough. And so you've probably seen these situations where someone tries to rob a bank and they just give the teller a note, I have a gun. And they may not actually have a gun, but if they're threatening to use one, we treat that the same way. And robbery is like that. So they don't actually have to use the force, but if they're threatening to use force, that's enough. So that's the common law definition of robbery, and most state statutes parallel that fairly closely. Burglary is another crime that we have. The common law elements were the breaking and entering of the dwelling of another person in the nighttime with the intent to commit a felony therein. So a little odd there, the common law definition. And notice it has to be at night, so technically if they break into the house in the daytime, it's not a burglary. Well, you have to remember, hundreds of years ago, they didn't have street lights and flashlights and things like that, so the nighttime is a whole lot more dangerous, and so they thought it was extra horrible, I guess, if you were doing this at night. The fourth element, the intent to commit a felony therein, basically, ordinarily the felony would be robbery, but basically you're breaking in, you're going to do something horrible once you get into the house. And it has to be a dwelling, notice that too. Burglary of a business wouldn't be burglary under the old common law definition. But most modern statutes have broadened this definition significantly. And so burglary can take place not just in a dwelling, but other types of buildings. Doesn't have to be at night, it can be in the day, and so on. So we kind of know what this is instinctively. We know what a burglary is. Somebody's breaking into somebody else's home or business or what have you, usually trying to steal something or trying to do something really bad. So that is a burglary. Larceny is another good old common law crime, and there's no crime of theft in the common law. A lot of times there's a statutory crime in most jurisdictions called theft, but the old common law would, if you stole something from somebody, it was either a robbery, a burglary, larceny, or something like that. But if you took property by force, that was a robbery. If you broke into someone's house at night, that was a burglary. If you stole something in any other manner, basically that was going to be larceny. So a pickpocket, would be committing larceny, or getting something through fraud might be larceny, something like that. So basically, it's non-violent, but you're forcibly taking property in some way, usually. Well, we've kind of simplified things a little bit. Most states have simplified the common law crimes, generalized the taking of someone else's stuff into varying degrees of what we might call theft. So again, the statutes have kind of simplified that a little bit. Receiving stolen property is another crime that might be relevant to your business career. Hopefully not, but a person receives stolen property with the intent to deprive the rightful owner of that property, they've committed this offense. You might see a situation where, like, a pawn shop owner knowingly tries to resell stolen goods. So certainly it behooves you, if you're in some kind of retail business dealing in used goods, to make sure that they're not stolen as best you can. But there is some kind of usually a knowing element, or reckless or something like that is the mental state. So normally, if you're just duped, you might not be guilty of this, but if you should have known, or you really did know, then you went ahead and tried to resell it, then you're guilty of a crime here. Arson, under the common law, was defined as a willful or malicious burning of the dwelling of another, so fairly limited. It was supposed to be a house, and it had to be someone else's house. Well, that definition has been broadened. Each state kind of started with that common law definition and then kind of ran with it. And so modern statutes make it illegal not only to burn down a house, but also, it could be a business or a church or some other type of building. Also, it might even be your own building. Some people burn down their own buildings to collect the insurance money. You could be convicted of arson for that. So again, same old story. The definition under the common law was kind of changed and broadened a little bit by various state statutes. We also have extortion, otherwise known as blackmail. The elements of that were that somebody wrongfully obtains the property of another with that person's consent, but that consent is induced by force, a threat of force, or fear. We kind of know what this is, that somebody finds out that so-and-so is having an affair, so they take pictures and then threaten to mail them to the wife unless they get money, that kind of thing. So they're holding something over somebody's head and getting them to write you checks, so that you won't reveal their dirty secrets or something like that. That's what we're talking about with extortion. Now we're really getting into crimes that are particularly relevant in the world of business. Forgery is a crime where somebody alters a written document in a fraudulent manner that affects the legal liability, rather, of another person. So we'll see this happen where, for example, you get a hold of someone else's checkbook, you make out a check to yourself, sign their name to it, that's forgery. So basically falsification of some kind of document. A lot of times it involves checks or something like that, but it can occur in various different situations. So we see that happen fairly frequently, unfortunately. Embezzlement is also fairly common in the business world. That's theft committed by someone who is put in a position of trust with respect to what has been stolen. So, for example, Sally's in charge of payroll at Smith's Auto Body. Every month when she's figuring payroll, she skims a little off of everybody's check and deposits it into her own account. Sally was put in a position of trust by her employer, and she used that position to steal funds for herself. And boy, we see that happen a lot. Just even within the Joplin area, I can think of 2 or 3 cases within the last couple of years where that's happened. So this is why it's really important to have controls, to where it's not just one person managing the books, that everybody knows what's going on in the checking account. So this kind of thing doesn't happen, because somebody you think you can trust, you might not be able to after all. And these types of crimes are called white-collar crimes a lot of the time, because blue-collar folks, are the ones that get dirty when they work, and white-collar people don't. And so, the kind of crime you can commit while you're sitting behind a desk, I guess, is a white-collar crime. Anyway, These are particularly relevant to the world of business, and something certainly, when your accounting classes are telling you about, how to avoid these sorts of things and to keep a good look on what's happening in your accounts. This is why, so we can prevent things like this from happening. We also have bribery, which happens when one person entices another person to abuse their position by offering money or favors. Both the offeror and the offeree are both guilty of bribery in this situation. And this will often involve people in official positions. So you might have a situation where, for instance, a factory can only get up and running if some government inspector shows up and passes it, and it passes inspection, and so they offer something to that inspector to make things go a little more smoothly. A little cash under the table or something. That's bribery. That's wrong. That's a crime. You get in lots of trouble for that. It's a particular problem for international companies because our culture in the United States just condemns bribery almost without question. Other countries have a culture where bribery is almost ubiquitous. And so if you're a multinational company and you go over to Sierra Leone or somewhere, in sub-Saharan Africa, let's say, you may run into every government official you deal with has their hand out wanting, some favors. Well, you can't do that. You can get in trouble in the United States if you offer bribes overseas even. So it's a particular problem, though, trying to deal with cultures that are different from our own. But anyway, bribery is bad. We also have fraud. Remember that there's also a tort called fraud. The crime is very similar to that. Its definition is the obtaining title to property through deception or trickery. So we get somebody's property away from them through some kind of trick, some kind of deceit. An example might be a fake charity. I don't know if you remember, there's a Seinfeld episode where George was going around telling people he had donated money to the Human Fund in their name. Well, there is no Human Fund. So if you're going around collecting money for the Human Fund, you're committing some kind of fraud. You're getting people's money through trickery. Another example would be a fake investment. If you're going around collecting people's money to invest in some venture and it's all a big fake and there is no venture that's going on, you're just taking people's money under false pretenses, and you're planning to retire to your little island somewhere with no extradition treaty with the United States. That's fraud. So we kind of instinctively know what that is, but that's the definition there. Well, most crimes are actually prosecuted at the state level. And most of the court activity actually in the United States occurs in state courts rather than federal courts. A lot of people don't realize that, but most criminal cases, I don't know what the percentage would be, but probably 85 or 90% take place at the state level. But there are some federal crimes that are very important in the world of business, especially. For example, we have wire fraud. And this is a federal crime because it happens across state lines. And so that's why the federal government gets involved, because it involves more than one state. And so the feeling is that basically any one state isn't as best positioned to take care of this as the federal government is. Anyway, wire fraud involves defrauding somebody. We kind of understand what that is already. But using the telephone typically, or the internet nowadays, to defraud somebody across state lines. That's considered wire fraud. That's a very serious offense, and that can get you thrown in federal prison. Or if you use the United States mail to defraud somebody. Again, that's a federal crime if it crosses state lines. And then, if you're using the U.S. mail, which is really a branch of the federal government, to commit your crime, very, very bad. That's a federal offense, can send you to federal prison. Something that's kind of unique is a federal statute called RICO. RICO, it's an acronym. Stands for Racketeer Influenced and Corrupt Organizations Act. People just call it RICO. And it was designed to fight organized crime. It was designed to get at the mob, basically. And we kind of know about that from watching TV shows and that sort of thing. But, the mob bosses, they would have all kinds of businesses that would otherwise be legitimate, but they're into all kinds of crime. And so basically, they might have some businesses that are legitimate and some criminal enterprises too, and they're using the money from all of them to commit more crimes. And so this statute was designed to shut all that down. And so just, cut the head off the snake here. And it was written fairly broadly, and although it was designed to fight the mob, it's been used all kinds of different ways against all kinds of different criminal enterprises. There's a criminal component of it. There's also a civil component. And so it's a fairly complicated statute, actually. Basically, it makes it a crime to participate in an enterprise. And an enterprise can be business, partnership, something else that engages in what's called racketeering. So again, we're talking about criminal activity that can involve all kinds of naughty things, and they're listed in the statute. It could be, other crimes such as robbery, drug dealing, violent offenses, white-collar crimes such as bribery or embezzlement, that sort of thing. So it's fairly broad, but if you're in one of these enterprises that's dedicated to committing these bad acts, you can get in trouble with RICO. Well, in order to have a conviction under RICO, the prosecuting attorney has to prove a pattern of racketeering activity, which is defined as 2 of the listed activities within a 10-year period. And so if they can show that, then you're maybe in trouble. If you're found guilty under RICO, you can be thrown in jail, fined, and the property of the enterprise can be seized by the government. And so, again, it's criminal and civil. You can be thrown in jail. That's criminal. They can also use RICO to go after all your property, which is kind of on the civil side. So a very powerful statute for federal prosecutors to use. Even if the enterprise is mostly a legitimate business with just some naughty stuff on the side, all the business's property can still be seized under RICO. So, again, very powerful, and it was designed also with that civil component. And the civil component is helpful for victims who were wronged by this entity that violated RICO. And so if the federal prosecutor finds people guilty under the RICO statute, and then the people that they defrauded or robbed or whatever they did can show up and then sue the defendants under RICO's civil provisions. And they can get treble damages. Treble means triple, so 3 times. So if they got, if they lost $100,000 to this criminal enterprise, they can sue and get $300,000. And so, again, it's a very powerful statute designed to fight the mob, but all kinds of different shady businesses have been in the crosshairs of it. So kind of unique, so certainly worth knowing something about that. Let's talk now about what are called inchoate crimes. With these crimes, the criminals don't actually have to complete the criminal act that they're intending to commit. So it's a little bit odd because, we do have to have that wrongful act, but here they kind of miss the target a little bit and don't completely finish the criminal activity they're embarking upon. We remember where we had examples earlier. We had a would-be murderer who shot at the victim but missed, and we said, well, there's no actus reus there. There's no wrongful act required for murder. Well, certainly that is true, but we can still punish that person because, gosh darn it, we don't want people shooting at other people. That's really bad. So that's something that the government needs to put a stop to if we're going to have that order and stability in society. So that person still needs punished even though they didn't complete that wrongful act entirely. Sometimes we just need to punish people for trying to do bad stuff so they won't ever try that again. We want to deter them from doing that and others as well. That serves as theories of punishment, deterrence, trying to get people to stop doing that stuff, incapacitating them perhaps. We'll throw them in jail before they can go try again and actually kill the person the next time. So certainly there is some valid reasons for doing that. And again, the set of crimes where we're going to look at where people can be locked up for trying and failing to do bad stuff are called inchoate crimes. Inchoate is how this is pronounced. So they tried, they didn't quite get the job done. Inchoate just means incomplete. They were really trying their best to commit some kind of bad act, but they didn't quite get it done. Our first inchoate crime that we'll look at is called attempt. Again, looking at our example where the would-be murderer shot at the victim and missed, what would, if we're feeling at all sorry for the person here who's convicted of attempt, consider what would happen if we didn't punish these almost happened crimes. What would happen if the cop showed up and told the victim, I'm sorry, we can't arrest him. He didn't actually kill you. When he does kill you tomorrow, when he, sights in his gun a little bit better and tries again, then we'll lock him up. That's not what we want to do. We want to stop this kind of activity from happening altogether. So even the attempt of committing a crime is something that must be punished. In this situation, the suspect had the mens rea, the evil intent in his heart, but he wasn't able to go through with the act. But he would have if he could have. And so that's something that we need to punish. The question that we have to answer, though, is how far we can go here without the government becoming the thought police. If you just sit around thinking bad thoughts about people, we're not going to lock you up for that. We're in a free country. We don't want to get to that point where that's even a possibility. So how do we balance those two concerns, stopping, this kind of criminal activity from happening that hasn't quite been completed yet versus not being the thought police? Well, to be convicted of attempt, you have to have two things. First, you have to be trying to commit a crime. And second, you have to take an actual step, or what the law says is an overt act, toward committing that crime. So it's not just enough to be sitting around thinking bad thoughts about someone. You actually have to take some kind of actual overt action toward completing that crime. So in the case that we had, our example, somebody actually shot the gun. They fired a bullet in somebody's direction. They just happened to miss. There we have an overt act. Shooting a gun at somebody, that's an action. So they were trying to commit the crime of murder. They took that actual step. They shot the gun. Ta-da, we have attempt. And so that's what we do. Now, sometimes there's a question of, how much of an action is actually enough of one to throw someone in jail? What if the person in our example hadn't actually fired the gun, but just went and bought the box of shells that they were going to shoot? Is that enough? Probably it is, but sometimes, it gets, far enough back in the timeline that it becomes a little bit of a gray area. And actually, this is just going to become a jury question at trial. We'll let the jury decide, was there really enough of an action to punish this person, or were they still in the process of, just sitting around thinking evil thoughts about someone? Or did they actually take enough of an action, to do that? Is looking up different types of guns on the internet, is that enough of an action? So sometimes it can get to be kind of a gray area. So that can become a jury question. Another type of inchoate crime we have is called conspiracy. A conspiracy happens when two or more people enter into an agreement to commit a crime. Just entering into that agreement is the conspiracy that we can punish in and of itself. Coming to that agreement with someone else to go commit a crime, that's a crime. Like an attempt, you can be guilty of a conspiracy even if you didn't go through with the crime itself that you're intending to commit. But if the members of your conspiracy made an overt act toward the commission of the crime, such as get together with a group of buddies, you're planning to rob a bank, and you go out and buy ski masks. Okay, well then we have a criminal conspiracy. And just this conspiracy by itself is a crime that we can punish. You might ask yourself, well, why is that? Well, wolves are more dangerous when they're in a pack, and so are people. And so we see it's especially dangerous when criminals get together and start planning stuff. It's bad enough when one person just goes off on his own and robs somebody. But if we have a group of people getting together and planning this out, this is really something bad that we want to deter. And so conspiracy in and of itself, as long as there's an overt act made toward the commission of the crime, we can punish that by itself. Well, that's really the end of inchoate crimes. I had something else I want to talk about that really fit on this slide really well, even though it doesn't belong here. And that's corporate criminal liability. A corporation is a legal person which can commit a crime. And we'll study this a little bit more when we talk about business organizations. But when you register a corporation, you create a new person. Legally speaking. And that person can own property, can sue and be sued, has to pay taxes, all that kind of stuff a person has to do. And that person can also commit a crime. Certainly the individual employees, the managers, they can commit a crime and they'll be prosecuted as an individual. But if the business itself is a criminal enterprise, it can also be brought up on criminal charges. Which you might think is kind of silly. You can't throw a corporation in jail, but you can seize it or seize its property or fine it something like that. So certainly the individual people who commit crimes will always be prosecuted for that. But sometimes the corporation itself can be charged with criminal liability, and so that can be a real problem too. So it can happen. It's not all that common, I don't think, but you can see it happen once in a while. A corporation will be brought up on criminal charges itself. So something worth remembering if you're running the business. We're going to turn now and look at the constitutional protections that we're given with respect to being charged with crimes and being accused, things such as that. Much of the Bill of Rights actually deals with this, deals with the rights of people who are accused of crimes, because that was seen as a real major issue. Back when they were writing the Constitution, the British had been kind of mean about this, taking away people's rights if they were accused of something. And so they wanted to make sure that people who were accused of crimes had their rights guaranteed. Over time, a lot of U.S. Supreme Court cases have come down defining these rights. They're very vague. That's how the Constitution was just written. But we have a lot of cases telling us what they mean in particular settings. They do apply both to the federal government and to the states via the incorporation doctrine. So whether you're arrested by the Neosho Police or the Missouri State Highway Patrol or the FBI, you still have the same constitutional rights. We're going to look at a few of these. This is one of those situations where, again, there's a whole class in law school where you look at all this stuff and it goes into nauseating detail. But we're just going to look at a few that might come up. You never know. You might be running a business and the cops show up and want to do with a search warrant, and you want to know what your rights are. So it's good to have a kind of a background on some of this without going into too much detail. We're just going to get an overview of what our rights are thanks to the Constitution and with regard to criminal investigations. Well, a lot of rights come to us from the Fourth Amendment. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. A lot going on in here, a lot of very important stuff. So let's take a look at it. First of all, it protects us against unreasonable searches and seizures. Well, certainly it doesn't protect us against all searches and seizures, but unreasonable ones. And what is unreasonable depends on the circumstances, and we have different court cases to tell us what that is. But the bottom line is that the government is looking for evidence of a crime and has to act reasonably. Normally, what that means is police must have some kind of probable cause that evidence of a crime exists in the place to be searched, or that the person to be arrested committed an offense. So, probable cause means more than just a hunch. It has to be some kind of reasonable belief that's based upon cold, hard facts. So, the police may think that, your business is, some kind of criminal enterprise, but just because they think it doesn't mean they have probable cause. They have to get some kind of evidence that will back up that idea, give them some kind of reasonable suspicion that something illegal is going on. In many cases, not all, but in many cases, the police must obtain a warrant before they conduct a search. To get a warrant, the police must swear under oath that they have obtained enough evidence to establish probable cause. And they go to a judge, and the judge will examine their statement that was made under oath, and then if he agrees with them, he'll issue a warrant that allows them to go conduct a search. And so, again, this is done under oath, under penalty of perjury. Policemen must swear that, this is the evidence that we have, this is what we think is going on, we need to go search this, this, and this, and the warrant will issue if the judge agrees. It specifically says, what can be searched, and also what they're looking for. They can't just go on a fishing expedition. So the warrant gives us a lot of protection by limiting where the police can go looking for stuff. And again, what is reasonable under the Fourth Amendment depends a lot upon the context. First of all, what's our setting? If you're in your own home, you have a very high expectation of privacy. A man's house is his castle, and the law kind of recognizes that. So if you're sitting at home, behind closed doors, you have a high expectation of privacy. And so what's reasonable to be a search there wouldn't be the same as if it was a public place. And so the cops might have to have more evidence to get a warrant. The warrant might be more limited than it would be in a somewhere else. So it depends on what your expectations of privacy actually are. If you take your trash out and put it on the curb, or out in the street, you have very little expectation of privacy in that. It's in a public place. And so, for heaven's sake, if you have evidence of a crime that you're throwing away in your trash, make sure that it stays in your yard, I guess, rather than put it on the street. But anyway, it depends on the location, what your reasonable expectation of privacy is going to be. Surprisingly to a lot of people, a car on a public road has not much at all expectation of privacy. First of all, you're on a public road. Second of all, unless you have a lot of that fancy window tinting, people can see in your car. So there's not a lot of expectation of privacy there. And police can search cars a lot more thoroughly with a lot less pretext than they can your house, for example. So again, it depends on the environment that we're talking about. Warrant is required most of the time, except in exigent circumstances, and that really just means an emergency. If a cop is walking down the street and goes past a house and hears a woman's voice screaming for help inside that I'm being beat up or something like that, he can go bust down the door and try to help her without going to the judge and getting a warrant first. If the police knock on the door where they think drug activity is going on, they hear the toilet flushing as they're trying to get rid of the cocaine or whatever, that may be exigent circumstances too. So again, it depends on the situation. Or if a policeman sees a robbery in progress, we can go arrest the perpetrator without an arrest warrant. So certainly it depends on the circumstances, but if we have an emergency, we don't have to go through the whole warrant procedure. Times the police can do a search just based upon consent. If the police show up and say, "May we please search your house?" and you say, "Oh, sure, come on in," that's consent. And stupid criminals inexplicably consent to searches all the time. If you've ever watched an episode of Cops, a lot of times the criminals will say, "Oh, yeah, I have nothing to hide," when they clearly do have something to hide. And of course, the police will search them or their vehicle or whatever the case is, and they will find evidence of a crime, and that's just silly. They should have just kept their mouth shut if nothing else. But if you invite the police in and, let them search, then, you basically waived your right under the Fourth Amendment there. So if you consent, then the police can do whatever you consent to, basically. There's always a situation that comes up with roommates, or you might have, co-tenants in a business setting or something like that. A lot of times we'll have a situation where the police will show up, knock on the door, and think that, a roommate is, a drug dealer or something. And then, one of the other roommates will say, "Oh, yeah, come on in and search." Sometimes they can give consent, at least to the common areas of the living quarters, and that can get the other roommate in trouble. So, again, consent waives your Fourth Amendment rights you would ordinarily have. Well, what happens if your Fourth Amendment rights are violated? Well, if the police should have gotten a warrant and didn't, and they find evidence of a crime? Well, the consequences that flow from that is what we call the exclusionary rule. So if you end up on trial and the police have illegally obtained evidence that they should have gotten a warrant for and didn't, or they otherwise violated your Fourth Amendment rights when they obtained this evidence, the court will just keep that evidence out. The jury will never hear about it. And so that can be kind of a harsh rule at times, because we'll have somebody dead to rights. We know they committed a crime, but if the police screwed up and they violated this person's Fourth Amendment rights, then we won't let that evidence in, so there's not enough to convict him, and we have to let him go. So there can be some hard cases there because of that, but we see the need to protect people's constitutional rights as paramount in that situation. We don't want the police just showing up and doing whatever they want to do and not suffering any consequences. And the view is, if we exclude the evidence they found, then that'll discourage that kind of thing from happening. So that's the consequences of violating those Fourth Amendment rights. The Fifth Amendment also deals with constitutional protections in a criminal case. It says, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service, in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So a lot going on in there. I've said this before. I think the founding fathers weren't thinking topically when they created the Constitution and the Bill of Rights. And so we've already seen the due process clause that's in here, but let's take a little bit of time and look at some of the things that deal specifically with criminal cases. First, we have the prohibition against double jeopardy, which we saw, and basically that just means that somebody can't be put on trial twice for the same offense, unless we have the situation where there was a mistrial, where the jury couldn't agree. That's really the only situation where, after a jury has been seated, we can try a person twice for the same crime. Let me take an example and just kind of show you how this works. In our example, Billy Bob is on trial for robbing a bank in the middle of the night. The only witness to the crime who testifies at trial is an 85-year-old lady with Coke bottle glasses. While testifying, she mistakenly points at the judge and identifies him as the robber. Billy Bob is found not guilty and let go. Okay, so Billy Bob is free. But the next day, I guess after reading about this in the paper, the President of the United States, the Pope, and Oprah all come forward and state that they had witnessed the crime as well and identify Billy Bob as the robber. Further, a surveillance tape is uncovered which clearly shows Billy Bob leaving the bank with a bag of cash. Even more damning, a newly discovered tobacco spit stain inside the bank vault tests positive for Billy Bob's DNA. So, can we try Billy Bob again with all of this new evidence? No, none of it matters. The prosecution had only one shot to convict Billy Bob, and it blew it. Billy Bob can never again be charged with that crime, no matter what new evidence surfaces. So it doesn't matter what happens. We already had one bite at the apple, and that's all we get. Once we couldn't convict him, we failed to convict him the first time. Doesn't matter what happens after that. Well, why, might you ask, would the government give you this right against double jeopardy and let Billy Bob off the hook in this case? Why don't we drag him back in after all of this new evidence and nail his hide to the wall? Well, the answer is we want to prevent the government from harassing its own citizens. Can you imagine what might happen if we had an abusive government that would falsely drag you into court, accuse you of some crime, put you on trial, you have to defend yourself, you're found not guilty, and so you go about your life, but then next month they say, oh, we've discovered new evidence, and then they put you on trial again. That doesn't work, so the month after that, look, we discovered new evidence, and they try it all over again. You can see quickly how that can become really harassment. And so in order to stop that, we just have this blanket rule that lets people off the hook. If we try to convict them once and we fail, then they're scot-free after that. So that's the prohibition against double jeopardy. We also have the prohibition against self-incrimination. You may remember there toward the end of the Fifth Amendment where it says that you can't be compelled in any criminal case to be a witness against yourself. So that means, for starters, that in your criminal trial, the prosecutor cannot call you to the stand to testify against yourself. But the defendant can testify if he wants to. He doesn't have to. And so, again, the prosecution, cannot call you as a witness. And in most criminal trials, what you'll see happen is the defendant will never testify because they don't have to. The Fifth Amendment gives them that right. And the jury is not supposed to hold that against them either. They're instructed on that. And so usually the defendant won't testify. Sometimes the defendant wants to. Usually that's a really bad idea because the prosecutor can then cross-examine them. And so they can, tear them up on the witness stand, and they'll usually end up worse off than they were. But in a desperate situation, if the defendant thinks he's going to jail anyway, he may get on the witness stand and try to do himself some good. So, but that certainly will keep the prosecutor from calling the defendant as a witness against himself. We can't do that because of this prohibition against self-incrimination. It also works even before you're in trial. If you're just being accused of a crime, but the police are questioning you, you can invoke this right. And we know that familiarly is the right to remain silent when being questioned. And so if the police are questioning you, accusing you of a crime, and asking you questions, you can say, I invoke my right to remain silent. And then if you do that, the police are supposed to stop questioning you and leave you alone, at least for a while. And the case law is a little fuzzy on this, but they may be able to come back at a later time and start asking you questions again and see if you're willing to talk now. But for a while anyway, they have to leave you alone and stop, not harass you or anything, asking you questions. So that's an important right if you're ever accused of a crime. And there is one situation, kind of the exception to the exception almost, where you can be forced to testify in a criminal case where you were potentially committing a crime. And that's if the government offers you immunity from prosecution. So let's say you have a situation where you're, a member of a criminal enterprise of some sort, but a pretty low-level person. But the government wants you to testify against the Godfather, to put the head of the organization behind bars. And so you say, oh, I'm not going to testify, my Fifth Amendment right. And they say, oh, well, we're not going to prosecute you for anything. Here's a blanket immunity from prosecution. Now you have to testify. And they can actually force you to get up there on the witness stand and testify in a situation like that. So it doesn't happen all that often, but it does happen. Also worth mentioning, Miranda versus Arizona, a very familiar case probably if you've ever heard of Miranda rights. This is where they come from. The Supreme Court figured out that these rights in criminal cases don't really do you much good if you don't know they exist. And so in Miranda versus Arizona back in the late 60s, they decided that police had to inform you of your rights when they arrested you. And that's called Mirandizing somebody. And I'm sure we've seen that if we've ever seen a cop show. You have the right to remain silent, and blah, 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 blah. And they'll read your rights to you. So this is one of those rights that they have to read to you, is your Fifth Amendment right to remain silent. We also have the Sixth Amendment, which deals with criminal issues. It says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So a lot going on in there. Let's kind of take that apart. First, we have the right to a criminal trial that is both speedy and public. Well, the speedy trial part makes the government put up or shut up. By the time they arrest you, they ought to have a lot of evidence. And if they need a lot of time to go gather it, they probably don't have much of a case anyway. And so this kind of forces the government to get on with it, basically, not have this criminal charge hanging over your head indefinitely. A lot of times, though, a defendant will waive their right to a speedy trial because they want more time to prepare too, because their lawyer is busy trying to figure out a defense. And so if they waive that right, then we can have a lengthy amount of time between actually being arrested and charged and actually having the trial. So the defendant can waive that, but you do have that right under the Sixth Amendment. Also, it has to be a public trial. We have situations in other parts of the world where a dictatorship, will have secret courts and they'll grab someone off the street and put them on trial and throw them in jail. And no one really knows what's going on. Well, we don't want that happening in this country. So the government can't just be accusing people and trying them in secret. Whatever happens needs to be public. And if you want to witness a trial, a criminal case, or even most civil trials, you can go to the courthouse and sit there as a spectator. And as long as you behave yourself, they'll let you watch what goes on, whether you have anything to do with the case or not. And so those are public, and they're open to the public. Sometimes we have cameras in the courtroom and stuff if it's a newsworthy case. And that's on purpose because we want to, whatever the government's doing, we want that to be out in the open. And that is how we make sure they're not violating our rights in some way. Also, this amendment specifies a criminal defendant has the right to a jury trial. Again, the defendant can waive that right and just have the judge be the finder of fact in the case. But for the most part, they usually see the jury as kind of an advantage because, if you can convince one of those 12 people that you're not guilty, that's all that you really need. You have the right to know what crime you're being charged with. Again, in other parts of the world, we might be thrown in jail and not even know why. Well, not in the United States. We have the right to know what we're being charged with. There's also something in the Sixth Amendment called the Confrontation Clause, which requires that any witnesses who testify against you in a criminal case must be made available for cross-examination. And it certainly would be unfair if the state said, "Well, we have this witness that says that you did it," and but the witness isn't there at the trial, and you can't cross-examine them and ask them about their eyesight and if they were really concentrating and try to impeach them or whatever. And so the confrontation clause requires that that witness be available, and that's a real problem sometimes. Like if a witness dies or something, unless her testimony's been preserved in a certain way, and with the defense being able to be present there and ask them questions, that can kill a criminal prosecution pretty quickly. So, but that is important. We need to be able to confront the witnesses who are testifying against us. Very importantly, the Sixth Amendment also contains the right to counsel. And remember that we have an adversarial system. It only works when both sides are ably represented by attorneys who know what they're doing. And so if the state is represented by the prosecutor and you're there representing yourself and you never been to law school, don't know what's going on, not very fair. And so justice only happens in an adversarial system where both sides can present their arguments in a convincing way, and then the judge and jury can make the determination of who has the better argument. So, and that's why people have a right to counsel. And in the modern world, we'll provide a public defender for them if they can't afford one of their own. Also importantly, if an accused criminal is being questioned by the police and he says, "I want a lawyer," and the police have to stop asking him questions until an attorney is provided for him. And so that's even a little bit stronger than the right to silence, because they could come back and ask you more questions if you invoke your right to silence later on after a break. But here, if you invoke your right to counsel, they just have to leave you alone until a lawyer shows up. So very, very important. Also, as part of this, the Fifth and Sixth Amendments and the rights that are in there, it's been determined that you have an attorney-client privilege. And so basically, you can't have effective assistance of counsel if you are worrying about what you tell your lawyer ending up being used against you later on. And so whatever you tell your attorney is privileged. That can't come back to bite you. And so that's encouraging clients to talk to their attorneys in order for the attorney to be able to represent them and do a good job at trial. One more thing to look at in constitutional protections in the criminal sphere is the Eighth Amendment, which is at least short. It says, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." It's short, but it's also very vague. And what does this actually mean? And there's been a lot of court cases that try to define this in particular instances. And it's actually open to interpretation. It evolves over time. $20 might have been an excessive fine in 1789 when this was written. But now it's almost nothing. So certainly we kind of have to have that evolve. But more than that, it's dealt with all kinds of things like prison conditions. Nowadays what might be acceptable and humane way to keep prisoners might not have been 100 years ago, or vice versa, I guess. Anyway, and it's also been used with the death penalty quite a bit, a whole lot of litigation over that. And the death penalty has been chipped away at over the years, mainly through the Eighth Amendment. So if you committed a crime as a minor, we're no longer going to put you to death for that. If you're mentally retarded, we can't put you to death because you might not have understood exactly what you were doing, and that's been the Eighth Amendment that was used to decide that. And of course, we also only impose a death penalty in cases of murder. So it used to be rape, was a death penalty crime and other things. So anyway, the Eighth Amendment is important in the whole criminal sphere here. Hopefully not something you will deal with on a daily basis in your business career, but that's one more thing that you needed to know, I think, to kind of have a real understanding of all the different protections that we have given to us by the Bill of Rights. So that brings us to the end of our discussion of the criminal law. Hopefully, you'll go through your entire career without ever having to deal with this. I certainly hope so. But it's certainly good to know about your rights and what these different crimes, their elements and all that kind of thing, because you never know, that might come in handy someday. So with that said, goodbye until next week. See you on the discussion board.